for me, my Bibia, because of a FunnTV GH. I wish was happening over Jumadi, so I'll be share, but like, and also subscribe to the channel and send me a bear for inside a bit to me, a cabin. And your call highway in this one, and SMP, and SMP, and Yaswapote, and send the business, and send the business, Tsatsu, Tsikata. I'm not able to your former lawyer, Kesi, I'm not a councillor, my JJ Jolly Jones, and all Catachia Parliament was a very communia, but no one to Tomunia, Omunia, but the Supreme Court and somebody on the man of Shoma, and somebody asked them Shoma, son, or Mundi or Moya, Supreme Court shouldn't overcome their boundaries, or Mumu or limits, no Mundi or Moya, because Parliament knows a whole lot of them, and no see at the Kesi, or Ghana or mine. For a bear and semblance, measure some of me, I couldn't put this out, Damas.
In my 70s, I'm still a young man. And I think by the grace of God, I have remained relatively young. So I believe I'll continue to be young.
What do you do? How do you do it?
I pray.
Okay.
I exercise a little bit, not as much as I should be. I'm not as disciplined in my exercise as I should be. But as I say, I pray for God's continued grant of good health. And I think that enables me to earn his grace.
Okay, Mr. Tsikata, I mean, regularly meeting you, I would have wanted to know a lot about your life and what you have been doing, what inspires you and whatnot. But I want us to get into it because we have just a few days to election 2024. The biggest legal issue right now in the country is the action that was initiated by the Member of Parliament who happens to be the leader of the majority caucus on the interpretation of Article 97G and H. I just want to know what your thoughts are on all of these things happening in the country.
Well, I think we should look at all these things with the seriousness that they deserve, because as citizens, we have responsibilities to make sure that the Constitution is respected by everybody, all arms of government, everybody. And so I think when we look at what happened in the Supreme Court in terms of certain orders against the Speaker of Parliament, and then the Speaker of Parliament trying to set them aside, there are a number of, problems around what has happened. Because first of all, orders were made against the Speaker of Parliament without his being invited for his side of the story. Honorable Afenyomakin, who had been affected by the Speaker saying that based on certain people vacating their seats, he was no longer majority leader, ran to the Supreme Court. In fact, he ran to the Supreme Court before the determination.
That announcement was made by the Speaker.
But he ran to the Supreme Court. He asked the Supreme Court by writ to interpret the Constitution and so on. And then he also filed a motion for an injunction on notice. So that motion would have had to be served on the Speaker, according to what he himself filed. Then, I believe the next few days, I think he filed on the 15th. Then, on the morning of the 18th, he files a motion, this time without the Speaker's participation. And the motion is called a motion for stay of execution of the Speaker's ruling. And he files it, as the records show, something like noon. And I mean, normally everybody knows that when you file anything in the Supreme Court, the registrar, will have to set a date and so on, because the Chief Justice will now have to empanel the court. Somehow, the Chief Justice was able to empanel, and apparently by 2 o'clock, the court was sitting. And not just the court sitting, but the court proceeded on the basis solely of what was put before them by Honorable Afenyomakin, and gave orders in terms of what he put before the court without anything being heard from the speaker. Now, this raises very, very serious questions within constitutional system. I mean, first of all, the idea of asking for a stay of execution of a ruling of the speaker, there is really no legal basis for a stay of execution of a ruling of the speaker. The court, the Supreme Court and other courts, have the authority to stay execution of decisions within the court system.
Okay.
But you don't apply for a stay of execution of something that happens within another arm of government, which is the arm of the speaker. Now, the impression was given that because this is a matter for interpretation and so on, therefore you can run to the court. But again, there are clear decisions of the courts themselves, including the Supreme Court, decisions which make it absolutely clear that you don't, under the guise of interpretation, take to the Supreme Court things that are within the preserve of other courts or other authorities in the system. Very clear decisions. And I think we have to have a little law class here because I like some of these passages from the decisions of the Supreme Court itself, to be laid out for all of us to look at, because all of us have a responsibility to protect what is in the Constitution. The Supreme Court is not a law unto itself, fortunately. Neither is the Speaker a law unto himself. We all have responsibilities. So when, for instance...
Would you then say that the Supreme Court erred in that?
Well, definitely, in many respects. In fact, as I will try to perhaps explain if there is time, it erred in multiple respects. As I said, in the first respect, just running and saying there's a matter of interpretation, therefore Supreme Court, I'm before you, is not acceptable. The courts have said in many cases, there's this case, for instance, Edriamwa and Chum, where it was stated, Aqua, the Justice of the Supreme Court, as he then was, makes the point that all courts, tribunals, institutions, and all individuals are bound by the provisions of the Constitution in the adjudication of disputes before them. In summary then, whereas the original jurisdiction to interpret and enforce the provisions of this Constitution is vested solely in the Supreme Court, every court and tribunal is duty-bound or vested with jurisdiction to apply the provisions of the Constitution in the adjudication of disputes before it. And this jurisdiction is not taken away merely by a party's reference to or reliance on a provision of the Constitution. So just running to court and saying, Supreme Court, I want you to interpret such and such for me, does not mean that the Supreme Court should go ahead and do that. The Supreme Court has to decide whether it has jurisdiction. And I'll give you another example of something that
But I thought that interpretation of the Constitution is the exclusive jurisdiction of the Supreme Court.
Yes, but the court itself has made it clear that that does not take away the responsibility of others to apply the Constitution. Every institution, every court in the land applies the Constitution. In applying it, they have to understand it. They have to interpret it in that sense. So courts have made it quite clear that when you talk about the exclusive jurisdiction to interpret, it is not everything about some provision of the Constitution that leads to the requirement of interpretation. Do you see what I mean? So
there has to be some parameters that has
to be met. And those parameters have been set out in judicial decisions of the court itself.
Right.
And basically, those earlier decisions of the court itself, that's exactly one of them. But there are even more recent decisions like when the Ghana Bar Association tried to take Chief Justice Aban's matter to court, and they tried to say that Chief Justice Aban should not be a Chief Justice because he did certain moral standards and so on. They took it to court. And it's interesting what the Supreme Court, said in that case. Because, in fact, in that case, they made very specific reference to the fact that Parliament should not overstep, the Supreme Court should not overstep its bounds, especially when it comes to parliamentary matters. And
Tsakata, in this instance, I know that you're trying to find the judicial decisions for me.
Yes.
But in this instance, where it appears that there's some misunderstanding, for the want of a better word, on what the provisions of Article 97 G and H means, what would you have had the Speaker or even the members of Parliament do?
Yes, let's go step by step.
Okay.
I'm saying that the Supreme Court, when it is faced with a matter in which somebody runs and says, interpret,
right,
they don't automatically say there's an issue of interpretation.
Okay.
The court is guided by its own precedents,
right,
in which it talks about what qualifies
an interpretation,
invoke its exclusive power.
Okay.
And they make it also clear that other courts also have the responsibility to apply the Constitution. And of course, in applying it, they also do something that you can call interpretation. But when we talk about the exclusive jurisdiction, it is based on certain parameters. So here's one of the statements that was made in the Supreme Court in respect of the Aban matter, for instance. The statement was made very clearly in the judgment of Justice Bega. He makes reference to another earlier decision of Chief Justice Archer, in which Chief Justice Archer, as he puts it, came out forcefully in support of separation of powers and the principle of non-justiciability of certain matters in these words. The Constitution gives the judiciary power to interpret and enforce the Constitution. And I do not think that this independence enables the Supreme Court to do what it likes by undertaking incursions into territory reserved for Parliament and the executive. This court should not behave like an octopus, stretching its 8 tentacles here and there to grasp jurisdiction not constitutionally meant for it. So this was what one of the judges said. There are other statements in that case by other judges, all pointing to the fact that the Supreme Court should be careful in not venturing into the territory of others. Now, so when the Supreme Court, without even giving notice to the Speaker, so that the Speaker can at least let his side of the matter be heard, when it does that, it's very problematic. And the Supreme Court, again, has itself said that when there are previous decisions, it has to go by them, because that's what the Constitution provides. Article 1293 of the Constitution. There again, very clear. The Supreme Court is bound by its own previous decisions. Unless it wants to depart by stated reasons, then it can do so. But here, the court did not even make reference to any of these previous decisions because, frankly, they did not give the Speaker a chance to put before them his side of the case. So based on Honorable Afenyo-Markin's ex parte application, as we call it, they made those pronouncements about the orders. Now, those orders are also very problematic because when you look at the writ that Honorable Afenyo-Markin put to the Supreme Court, he wanted an interpretation of 97(1)G. You talked about G and H, but in his writ, he actually did not say G and H. He said G.
Right.
And so H, which is about Honorable Esiama, the Deputy Speaker, was not part of what he took before the Supreme Court. People lose sight of that.
Right.
Now, so if he took G to the Supreme Court, the Supreme Court had no basis for bringing in orders in relation to H.
Right.
Because that's not part of the writ. Additionally, as I think was pointed out by counsel for the Speaker when he tried to set aside the writ, you have a situation where the papers that were filed by Honorable Afenyo-Markin were deficient in terms of the rules of the Supreme Court itself, because the rules of the Supreme Court required Honorable Afenyo-Markin to have an affidavit that verifies the statement of case that he filed, because an affidavit involves somebody stating on oath certain facts, and on that basis the court can act. In this case, there was no affidavit, so all that was in the statement of case lacked verification. And essentially, when the Supreme Court in its ruling was talking about things like constitutional crisis and so on and so forth, it was relying on things in Honorable Afenyo-Markin's statement of case which had not been verified, and therefore they could not be relied upon as evidence before the Supreme Court. And when you have clear rules which require that for such an originating process you must have an affidavit, again, there is judicial precedent for insisting that in those circumstances the proceedings are void.
Right.
So they should not have proceeded without at least taking account of the fact that there was a deficiency in terms of compliance with their own rules. So that again is a problem. As I said, there are multiple reasons.
But forgive me for taking you back just a little bit. You talk about invoking the exclusive jurisdiction of the Supreme Court to interpret certain clauses in the Constitution. Are you saying, with the precedent that you give out, that even in this matter, that jurisdiction had not been invoked?
It had not been properly invoked by Honorable Afenyo-Markin's writ before the Supreme Court.
Okay, so then takes me back to the question that I asked you earlier. What would you have had them do?
What would the Supreme...
What would you have had Afenyo-Markin's, for instance, and the Speaker do?
First of all, the Supreme Court, I believe in this context, using its own rules, should have pointed out to Honorable Afenyo-Markin that there was no affidavit verifying the statement of case that he had filed before them, and therefore his writ was deficient, and they could not proceed on a deficient writ. I think that would have been a simple end to the matter. Secondly, if the Supreme Court wanted to give any guidance to a plaintiff who has not complied with their rules, they would again just refer them to the rules and give them the opportunity, if they thought appropriate, to correct those. Because, again, the rules of the Supreme Court will make it clear that non-compliance shall be a bar to further proceedings unless the Supreme Court waives that. There's nothing in the record which tells us that the Supreme Court waived anything by way of, sort of dealing with a non-compliance that there was, just on the face of things. So then the reason all these things are important is not just because of technicalities. The reason these things are important is because the rules enable us to ensure that things are done properly in an orderly fashion, and that whatever then comes authoritatively as a pronouncement of the Supreme Court appropriate authoritative decision that we can all go by. But where we see so many errors in terms of how the proceedings have gone, it just undermines the authority of the Supreme Court. And this is really important because, again, as I said earlier, all of us have a responsibility to respect the Constitution and to ensure its enforcement. So, for instance, if you go to Article 3 of that very constitution, it makes it quite clear that if any attempt is made to go against the constitution, we all have a duty to resist it. And that attempt can be made not just by people wearing military uniforms, it can be made by people wearing wigs and gowns as well. So we really have to take seriously our responsibility, all of us, to be familiar with what the Constitution provides. The Constitution is not just some arcane set of words that lawyers can, indulge in and that judges can make pronouncements of. The Constitution, is the supreme law of the land, and it's very clear in the Constitution, for instance, that the exercise of that judicial authority itself is on account of the sovereign will of the people, which is embedded in that Constitution. So these are really serious matters, and I think that it is sometimes too simplistic for people to give the impression that the Supreme Court has made a statement and therefore, you have to go by it before you complain and so on and so forth. In this particular case, as you know, the Speaker actually took the opportunity of having his counsel go and try to set it aside.
And when he made the attempt to try to set it aside, the Supreme Court affirmed its earlier decision.
Yes.
And I'm sure that you have heard persons like Katie Hammond speak that they were going to cite the Speaker for contempt because he is not obeying the decision of the Supreme Court.
Well, I would like to see that application by Mr. Katie Hammond, Honorable Katie Hammond. He was a student of mine too. So I'd like to see how his legal professional caliber stands up in terms of whatever he puts as in terms of contempt of court. But you know what?
But when counsel for the Speaker has tried to set it aside and he wasn't successful with it, shouldn't the Speaker obey what the Supreme Court said?
That cannot be the end of the matter, because as you know, for instance, there are rights to review a decision of the Supreme Court. So it can be the Speaker's prerogative to ask for a review. But you see, one of the aspects of what happened when the Speaker's counsel went to the Supreme Court to try to set it aside, one of the aspects which again is extremely worrying is that he objected to a member of the panel, Justice Guyu. Now, barely had he started raising the objection than, as we all saw on TV, the Chief Justice said, okay. And, so it's like he could not even articulate fully the grounds of his objection, except his first sentence about how Justice Guyu had been a parliamentary candidate or something at some point in the past. Now, there are many problems, again, with the way the Supreme Court proceeded there, because there's clear precedent that if an objection is raised against a member of the panel, that member himself cannot sit on the hearing of the objection. In other words, Justice Guyu, being a member of the panel which decided that he was not disqualified, is very odd. I had a case in the Supreme Court not too long ago where, on behalf of a party, I raised an objection to a member of the panel. That member of the panel happens to be the current Chief Justice now. I raised an objection. The court wanted that objection formally put. So we put it formally in writing. And the court constituted a panel which did not include her to hear the merits of that objection. And in the end, the court decided that she should be disqualified from sitting on that particular case. But in hearing the objection, she was not a member of the panel any longer. After we raised the objection initially orally, and the court asked us to put it in writing, the court was differently constituted. At that time, the Chief Justice was Chief Justice Eninyeboah. And so he excluded the person against whom we raised the objection. The same thing happened in the famous Salah case many decades ago. Everybody knows about the Salah case. An objection was raised against Justice Apalu at that time, And Justice Apalu did not sit on the panel hearing the objection. There was what was called a trial within a trial conducted to hear the merits of the objection that was put forward by the then Attorney General, Mr. Victor Usu. And in the end, the court that heard the objection heard evidence and decided that the objection should be should be dismissed. And the objection was dismissed, and Justice Apalu continued to sit on the salakate. But you don't have the person against whom the objection is raised hearing the same matter about his own objection. Then he's being a judge in his own cause. I think you're a law student these days, so I'm sure you're familiar with all these expressions. And so, you know, unfortunately, I guess because of the haste with which the court was proceeding, a lot of missteps have been taken.
Okay.
And those missteps, I think that the court should itself find an opportunity to retrace its steps so that those missteps do not count against it in terms of the future records of the Supreme Court.
Okay, in wrapping up on this thing, Mr. Tsikata, as an officer of the court, you've been practicing for many years.
But I'm not an officer of this particular court because I'm not appearing in this particular matter. But
generally,
as a professional,
yes, generally, what is your understanding of Article 97(1)(g)? What if you were a speaker? What would you have done?
You know, in this particular case, I think that the speaker, from all accounts, made reference to an earlier parliamentary precedent. So, in a way, it wasn't the speaker doing an interpretation, but essentially relying on previous proceedings of Parliament and saying that this precedent is there and so on. I have not, I've not familiarized myself with the full details of the proceedings of Parliament that day. But from the reports that I've seen, the speaker was basically using a previous precedent within the parliamentary processes. So in that sense, if somebody is going to take on the matter, like I said earlier, then before the Supreme Court takes it up as really a matter of interpretation, first of all, it must satisfy itself that it's
subscribing, so I subscribe. Said there are new political dated videos. Be a nam kwe movie. I be a one side. Ebe to me akebi. Tsikata. In some way, our kind and in Juma be the former lawyer Kesi. No one my man. Nim the own nim ever politician. I be doing come be actually a fofra patch up. Get here. If you two are women, boy, bra. The do be Akroma.